and Eva now.
Well, I just realized that I'm actually the only one on this panel who has already given a paper, so I will keep it short. And I would like to comment simply on the last 3 days that we had, and the things that stuck in my mind that I want to ponder a little bit more about, or that I would like to discuss all of us a little bit more. One is the problem of concept stretching. I might say something that is very old, but I still believe, and a little bit it came out already in the comments by Adam, you know, what are we talking about? The title of the conference, Legal Frames of Memory, on the one hand, for me these are two different things, legal frames of memory and transitional justice. And during the conference, for me, this came out very well as well, that we are, that somehow by putting, we tend to, in this conference, we have tended to now call everything transitional justice, whether it's memory or whether it's actual dealing with the criminals or with the victims of crimes, or whether it's much later retrospective trying to come to terms with past wrongdoing. It's all, you know, or civil society agents of memory, or even of actual, you know, interest in getting compensation. All of that is transitional justice, and I think for somebody who sees this more as an analytical term, this is a little bit problematic, and I always like to draw lines. And one thing that struck me was, for example, that all these European debates, well, especially the European Court of Human Rights, but also these domestic courts that have paragraphs on the denial of Holocaust, like in Germany, or the denial of communist crimes, like in Hungary, Czech Republic, Poland, and also Lithuania and Latvia. These are parliaments trying to legislate memory. This has nothing to do with transitional justice anymore, from my point of view. We might disagree, but this is not transitional justice. And so in many ways the European Court of Human Rights, you know, legislate or ruling on cases, but there we have to differentiate, ruling on cases like the Hungarian case that we just heard about today, with somebody wearing the Red Star. This is again, in a way, a judgment on memory. But when it comes to Ždanoka, for example, the Latvian case, this was a case where the European Court did a judgment on a transitional justice case, because Ždanoka's exclusion from running for parliament was a measure of transitional justice in Latvia. So that helps to distinguish, to have clarity in conceptual terms, rather than blurring everything as transitional justice. That was just one thing, and we can discuss that. The other thing also concerns the European memory struggles, which I see very much as indeed memory struggles. So trying to find a common memory, and there has been lots written about this. And here again we have then the legal aspects of this, and as we heard, the European Union is very critical in actually addressing the memory of communist crimes in criminal or in legal terms. But it has been very active indeed, increasingly active in sort of more symbolic recognition of that memory as part of the European heritage. And that we see in various programs of financial support. So as I already mentioned in our discussions, there is a lot going on, and I think I wouldn't be so pessimistic about young Western Europeans never knowing what Khatun was. I think at some point they will. It's just taking more time. And I think that time was necessary for the memory of the Holocaust, and it is simply necessary for the memory of communism. But it is, thanks to, you know, much activity here in this part of the world, and much of organization now and networking among different organizations, there's a lot of lobbying being done in the European institutions and among European educators, that I think this awareness is going to raise. Maybe it will take another 20 years, that's very easy, but with this kind of more positive remarks, I would like to just open the floor then.
Okay, thank you very much, Eva. Thanks to all presenters, and now immediately I want to open the floor for questions, remarks, comments, discussion. So Joachim, Cosmin, the gentleman over there.
Thank you. I I will keep myself very, very brief. And I have a question for Adam Czernota. I'm not sure if I understand you correctly, but I heard you say that transitional justice in part is a replacement of the political by the quasi-judicial. Did I hear you say that correctly? And it serves the function to suppress politics. And I can understand completely what you are saying. It is an interesting question about the democratic process of revolutions, right? The American Constitution, that is the foundation of a long-lasting democracy, is not itself the product of a democratic process. I think at the beginning of the creation of new states, there is always something that is not democratic in nature. So we shouldn't expect that to be the case here. I also wanted to ask if maybe it would be appropriate to say that the function of transitional justice, of something political by something quasi-judicial does not serve the function to suppress politics, but the function to suppress bloodshed. This certainly was the goal of those who practiced transitional justice in South Africa, for example. And I know all the criticisms, some of them I deem valid, of the Truth and Reconciliation Commission. But we do not know about the bloodshed that would have occurred without that commission. We don't know the anti-factual. So thank you for your comments. These are questions.
Okay, Cosmin?
Thank you very much. I have some comments and related to Adam's and Eva's presentations, and I'm trying to link this question which Adam brought here, the question which he saw as being the great lack, the question of legal continuity, and I would try to link this with Zeva's concern about the conceptual clarification about transitional justice. How does transitional justice really takes into account the question of legal continuity? Because to some extent, I think this is the whole problem also with the conceptual clarification in itself. Because otherwise, what you have what Hart would have called the pathologies of law. You have a change in a legal regime. But when do you know that the change has happened? And to each extent, in fact, memory comes into play here. So that would be the...
Thank you.
Ja mam konkretne pytanie.
I have a typical question, a journalist and historical question to Adam. Professor Adam, probably the people in this room will not remember or will never have heard of a so-called Finlandization of law, something that was specifically Polish under the rule of President Wałęsa. These were different, not fully defined legal acts that were adopted by presidential lawyers, especially Mr. Falandes. And how can we deal with subjective memory and objective knowledge and particular events, decision makers, people behind the scene? And the question is whether we, in the law-abiding state, where we proclaim that the Third Republic of Poland is the state governed by the rule of law, will we be able to somehow come to terms with the impact of political elites on the law that is being made. It is known that in Poland the legislation is not perfect, and the whole series of laws and acts adopted by the parliament in its previous terms in office require amendments, and this is an open question. This is an open question about the quality of law, its understanding and its application. I'm a spokesman and a volunteer acting on behalf of such a Polish citizen whose court procedure for division of the property inherited has been ongoing for 37 years, and the next hearing will take place only next year. Some of his siblings are no longer alive. One of his brothers, who was a communist apparatchik, suddenly decided to donate the family house that was owned by all of them to someone else, and this was then authorized by courts. So the incumbent Minister of Justice and the Member of European Parliament, Janusz Wojciechowski, finally decided to represent the citizen, asking the Supreme Court of Justice for cassation of the previous decision. And this is the key to many questions, to many problems. In the context of what Jarosław was saying, there is a book written by Andrzej Szeptycki, Ukraine versus Russia, an excellent work in itself, an excellent reading. And here we read about the selective knowledge and selective memory of certain events, not to mention the famine, the Holodomor. There is a lot of mention about Russian-Ukrainian, Ukrainian-Russian relations, something that impedes in the progress in Ukraine after the Orange Revolution. Thank you very much.
Thank you. Thanks a lot for these wonderful comments. Joanna Wawrzyniak, I have just one generic question, which relates to the one topic which adds one more topic to the list of the topics were perhaps not discussed enough during the conference because we didn't have time. So the question is, if, what, and how all these transitional justice debates and issues relate to the debate within political science about the party system in the Central Eastern Europe. Well, I've studied political science a long time ago, and then I just returned to history and sociology. So, but I do remember the debate, which was around, I think, 2000, about how to deal with the party system in this new democracies with comparison to the established democracy. And then when the political scientist studies this famous Kirchhoff axis, they added to that the so-called post-communist divide. So that was kind of the one answer, that there is something different in these societies. The second one was just a provocative statement of one of the Polish political scientists, Markowski, when he wrote in Gazeta Wyborcza that perhaps right now we have already came to pillarized societies within, at least in Poland and perhaps also in other Central Eastern European countries. So there are just two different societies. One would be kind of post-communist one, and the other one would be anti-communist one, and they should have the different representation because they would never come together to the agreement. So just my question is, if and how today this question of transitional justice and other do come to some models, or do they, they're used to build some models which are supposed to explain the party system in the region. Thank you.
Okay, thank you very much. And now, shall we start in order of Jaroslav, Adam, and Eva again?
I don't know whether I understood your question correctly, but of course, transitional justice research on Eastern Europe has very much argued in the last years, trying to figure out what are the factors determining elites to make the decision for or against measures, and also the scope of the measures, etc. And of course, the emerging party system has a major impact on the political dynamics that then determine decision making. So you have, in looking for explanations why countries go this or that way, then obviously in those countries where you have a strong ex-communist party that has electoral success, again, comes back to power, you usually see, like in Poland or in also Lithuania, where you see stretches of rather mild, lenient, or non-existing even justice measures, followed then by later, once the, in this kind of polarized party system, also these issues stay on the agenda. Usually they tend to stay more on the agenda than in other countries where this is not such a strong, the anti-communist, communist cleavage is not so strong. So in that sense, these two have been linked, if this is what you were asked, the kind of party system development and transitional justice measures, indeed, yeah.
Okay. Well, thank you very much for the questions. I just want to put your attention to what Istvan said before he left, right? It means what Istvan tells us in the nice world, basically, that TJ is a huge industry nowadays. It means there's a big money involved in this, and there's just sort of the, repeating itself, the machine. I also, since Istvan left, and I can't be accused of advertisement for him. So I want to read you something what he wrote actually in the very, very good book called, with title Retroactive Justice, Prehistory of Post-Communism, published in 2006 I can't remember by which publisher, but in America. And as he wrote, the object of my study is the remake of the dead, the martyr turned unknown soldier, and back again, the criminal who is redeemed as innocent, holidays banalized, cemeteries reconstructed, and unremarkable figures presented as historical monstrosities, ordinary places rebuilt as sites of horror. My book is not devoted to the traces of time gone by or representation of past events, but to phantoms. It deals with the bodies and objects that are presented as visible, even tangibly, incarnate, instead of the notion of substitution. I study manipulation by hand, undoing by remaking, the end of citation. And in this book, what he wrote, he precisely showed how the law is used in this undoing by remaking. It means by falsifying somehow the past, not to do any type of justice to the past. Now, the answer to the questions. Well, Joachim, I'm absolutely conscious, right, about that could be some sort of the sinful beginning with the relatively good outcome. But it seems to me that we can't repeat the same, or say to show, there was a constitutional moment which was not fully democratic in the beginning of USA, and that will apply everywhere, right? It means it has to be, there are no some general social pattern in this case. That is a particular approach, not a general approach. And what's happened here, precisely, it seems to me, at least in some countries of Central Eastern Europe, that was a huge democratic mobilization, and then after breakthrough, conscious demobilization of people. For what reasons? I don't know. I don't have the answers, but I'm asking the question. And probably it seems to me there is plenty of different answers nowadays connected precisely with acceptance of one or another historical narratives. I do agree with you that in the case of the armed conflict, right, the most important issue is stop armed conflict or stop hostilities, to block them. and in such way to force both parts, or more parts, to start negotiation, start talking to each other, but only in the case of the armed conflict. In such cases, we could talk precisely about some sort of design when you crush this passion of the politics in order to open up it later on, or to channel that. Right? When here it seems to me the situation was a bit different. There was not armed conflict except the Balkans in the, in the former Yugoslavia, but some sort of the negotiated revolution. And the negotiated revolution, what is it? Rule of law revolution, as was told by the Hungarian Constitutional Court. But really, rule of law revolution, I don't want to make evaluation, it's too early to say, but it has to be taken into account. Then, continuity, discontinuity, Cosmin. It means, what is the role of memory in continuity or discontinuity? Well, I mentioned legal continuity, right? It means that's not my invention. That's a banal truth only. That actually, in the plenty of in the situation of Poland, right, the Roundtable talks in Poland. That was the first time when the dissidents actually acknowledge and provide legitimacy to the communist regime. And that is what I don't want to say, that in my interpretation, actually, the outcome of the Roundtable talks, they were creation of the super constitution, which is signing of the agreement, and the real constitution after that was simply according to the norms which are already agreed upon. So it means a constitutive moment was at that time, not later on. The momentum, according to Ackerman, is being lost. Right? It means to do something else. So I think at the moment I never thought systematically on this issue, but it seems to me that the issue of the legal continuity is one of the crucial elements in any conscious reflection upon the concept of the dealing with the past. Now I will shift to Polish because it's a falandyzacja prawa. I don't know even how to translate it to English, right? It means sort of the manipulation with law. Falandyzacja prawa.
The distorting of law, falandization of law, as we put it in Polish. Yes, we realized this. I was not in Poland back then, so I had no first-hand experience of falandization. But it is not so that law is always objective. It is subject to interpretations and construction. Professor Falanders, the legal aid to president, was very creative, and he was very capable to come up with creative construction of the law in force. In the legal system, there is a number of legal institutions installed which limit the creativity of construction of interpretation. However, in Poland, we had a system in place that was not stable. We were still in the process of construction. The construction was still underway, and the law was instrumentalized. Justice and the administration of justice, this case on inheritance. Well, law has something to do with justice. As a lawyer, I'm first to admit it, but it doesn't have to have anything to do with justice. Legal certainty may be more important than justice, and there is a merit in it. Legal certainty is a value in itself, taken holistically. Also, it seems to me that there is a number of real-life scenarios and social scenarios where law will not be sufficiently capable epistemologically to counter certain situations. For instance, an amendment is needed or a turnaround in legislation is needed. So the existing legal institutions are not capable of resolving something. But the knowledge of judges, how do you evaluate the level of knowledge and information among our judges, subjectively even, if I may? Well, this is a follow-up question. If you would like to look at the research that was done into the subject in Poland, the sociology of law has been created here by Pelczarzycki, Podgórecki, and one of the specific analyses that were run in Poland was the prestige of the profession of a judge. What kind of prestige was associated with the profession of a judge? Empirical studies about how judges are perceived in Poland. Unfortunately, the prestige is very low and going down year in, year out. So this is about the level of information among judges. Thank you.
It's very interesting for me which way to create legal continuation in the context of the absence of moral norms, values, orientation in the situation of moral corrosion in post-Soviet societies. Which way to have balance between different models of historical memory, and which way to initiate legal reforms in post-Soviet countries. So what's way? But in the context of post-Soviet models of colonialism.
And another question is Christiane and gentleman over there.
Thank you very much. I was just thinking about some of the things that kind of law can't quite do, or that actually we can be tempted to thinking that it can and that would be good, and maybe that's worth thinking about. One is, I thought during the property panel, we have this idea that if we turn some property transactions bad, that would be more just. Now, if you look at how property and real land has been established all over Europe, and I know in the region I come from, highly inequitable. I mean, we're talking about people marrying somebody 200 years ago, with somebody winning a war, and then using our law today to try to vindicate that mode of property acquisition. At least there's worth putting in a question mark that often isn't put in if we just have this doctrinal legal analysis. And also more generally looking at, like, what is our standard of justice, and in a German context specifically, and I think in the larger European, what Western European states have done counted as justice. And one very painful example is West Germany had continued to criminalize homosexuality between men until very, very late. So when East German men who were convicted of homosexuality wanted to be rehabilitated, they were told, nah, because the West German state did it, therefore it was normal to criminalize what you did, and therefore, sorry. So that in effect, the kind of the sense of morality and rightness of certain legal systems and norms is vindicated by the fact that we try to repair other things. That's something I'm worried about, and I'm sure it's in more examples than the one I can think of right now.
Dziękuję, Zbyszek Kowalski.
Thank you, Zbyszek Kowalski. Ladies and gentlemen, my starting point is the very word transitional. Transition for me is somehow associated with exchanging experiences, coming to a consensus on the basis of a common transition. So for me, it is about working out a certain joint model, and I accept it as a beautiful ideal of justice in Central Europe, Central and Eastern Europe. Whereas Norman Davies, we know him as a famous historian in Poland, officially he undermines whether it makes sense to use the notion of transitional justice. And citizens of Central and Eastern Europe, where this notion functions, believe that perhaps it should no longer be used. The best example is Katyn massacre, because how is it possible to come up with a joint position of Poland and Russia on the matter of accountability for the crime? It is not only several thousand of Polish officers who were buried there, but there are people from all over Europe, from Belarus, from Ukraine, from all over Europe. It is not only the Polish thing, the part of Polish history. So a question to all of you. Are you absolutely certain that it makes sense to use the notion of Central and Eastern Europe? Because even now, between Hungarians and Romanians, there are some disputes. Between Poland and the Czech Republic, Zaolzie, I guess that there might be some potential dispute. So there are so many matters which were unresolved. Hence my question. I have a question. I'm not certain what the answer should be. But perhaps we should think it over.
Okay, there's very serious two questions, it seems to me. Well, be honest with you, I don't know how to answer. It means I don't have recipes. But I could, in the post-Soviet space, it means, if I understand it correctly, the question was, well, how to build up a new polity in the post-Soviet space, upon which, actually, background, what sort of the platform to use. And on the one hand, what is, I could, no, let's make a sort of the distinction. On the one hand, you've got a social, and then is this legal one, right? So it's quite relatively easy to show. Okay, we could invent some new institutions, but this institution will be empty. So it means the institutional design is empty as long as you don't fill this institution with some sort of the life coming from the social background. So. Probably, it seems to me, this is a particular question. Can we identify, actually, in the particular case of Ukraine, some areas which could be used and provide support for the new institutions? But sorry for that, I don't have a knowledge. It means I don't know, I don't study what is going on in Ukraine. And probably it seems to me in all those post-Soviet areas, different type of social energies, right, were used for the building up something new. And all of, now, that's, again, sort of the banal statement, but you see, one opening sentence, right, in the Tolstoy, Anna Karenina is, each happy family looks alike, each unhappy family is unhappy in its own way. And that's precisely the case of each this country dealing with the past. It means each country is really unhappy with dealing and with building something new. Now, so I don't have an answer. Nobody has at the moment, seems to me. But one suggestion: never give up. That's something what I could say. Christina, this question about this. If I understand you correctly, you asked the question: who actually, or what or who dictate the normalcy? It means the normality as such. Well, that's a political struggle, it seems to me. Right? Simple answer. It means the outcome is purely political. There are no some universal, norms which dictate that. But that's why talk about the objective concept of the past is a mistake. Or talking about the one objective memory or harmonization of memory is a mistake. There is always contested social phenomena. They always will be contested social phenomena as long as society exists. So when I listened to this talk given by Professor Barkan, it was really, I like it. His heart is on the right side. He wants, this nice social space for the common talk. But what I miss in the talk is identification of the conflicting interest. It means how they blocked, how they channel this type of the conflicting interpretation of memory. So the picture is not very rosy. In opposite, is a tragic but not hopeless, or hopeless not tragic, but which means is a always struggle, contestation. The same is law. Law is a contested social phenomenon. There is no one such objective type of law. It means that people fight for their own rights or for their own concept of justice. And the last part about the last question about the concept of Central Eastern Europe, it depends. I mean, I'm not very emotionally deeply attached, but at the same time I like it. Right? It means if somebody will tell me that is a Neumann's concept of the Middle Europa, then I am against it, right? But if the Istvan Bibo will tell me about this concept of a Central Eastern Europe as a Europe of the small states, basically, which each of them struggle with their own past and identity, then it seems to me each of us here, from the Baltic down to the Balkans, possess some sort of the similarities. And the similarities were especially reinforced during the communist regime.
Next questions. A lady here, gentleman there, and any other questions? So we have 2 questions.
I'm afraid the mic is not on. I can't hear the lady.
How long should be existent new convention of law? Because justice, universal justice, should be obtained in morality and in education, universal justice, like IDEA, of course. But I am sure that in life only taxes are sure, of course. But for me, it's uncomfortable that we talk only about events for transformation in Poland, and didn't talk about mistake in this transformation. Very objective, but mistake, political, economic, in Poland, in Polish transformation is very is not stop in future.
Yeah, this is a great conversation. Thank you very much for this animated discussion. Actually, I have a question for Adam Czarnota. I mean, thank you for bringing out this and problematizing this field of transitional justice, which sometimes seems so obvious that it obscures its origins too. Its very formulation with a certain model in mind. And I'm just wondering, this is a question for clarification actually. I'm wondering if you count lustration as part of the instruments of transitional justice. And the second thing is that I'm also... Lustracja. And I'm also wondering if where does this word come from? Okay, if it is the Czechs or the Czechoslovaks invented that word lustration, but then why this particular word is chosen for this model of justice? And because, I mean, there's this Roman, sometimes in the dictionary, this lustratio, it comes from the purification by sacrifice and so on and so forth, but maybe it has a certain, it has a different origins than what it means, actually, that word. And the second thing is that I am also, I find it very, very important to remark that the field of law is also law of strategy and conflict and struggle. And it's always a product of contestations of the legislations and so on and so forth. And this is especially, I think, the case in Poland. The legislation of restoration laws and different legislations, and has been disputed so much by the Constitutional Tribunal in different years throughout, and especially mid-2000s. And the Helsinki Human Rights Organization was very much involved to monitoring the court proceedings and so on and so forth. So it is never obvious in Poland whether restoration exactly represents, at least the way it has been implemented, represents human rights advocacy for sure. So because there are all kinds of different claims on restoration from different parts of civil society too, if you will. So I'm curious about your opinion on this contentious history of Polish restoration in the broader framework of transformation, like political transformation, capitalist transformation too. Thank you.
Okay. Adam. Yeah, here.
Well, to the first question, even by the lady over there, well, to make a mistake is normal, right? It means, especially, there's not some blueprint for the conducting social processes, or especially in the accelerated social change. But what interests me actually is what is the impact of the institutions on such processes, right? Can we invent some institutions which will channel the changes in the peculiar direction without telling what is the end effect, but somehow channeling in the one direction? At the moment, I don't have an answer. There's plenty of levels of literature upon that. Then your question about the how long the convention of law should stay. Be honest, I don't understand, because there is always, it's not something stable. I only say that it's easy to change the law, and as you know, the Polish parliament is pretty creative in the acceptance of the new statutes as fast as possible. And there is a creation so-called, what the legal sociologists called bad law, right? It means a law with bad social effects. But law is not something in action. Unless you believe in the natural law, which is stable, unchangeable, then always law is a subject of the change. And now the next question, it means a question about lustration. Yeah, I do, I include this lustration to the problem of dealing, as one of the strategies of dealing with the past. But when we talk lustration, we have to be much more precise. It means, what do you understand by lustration? There are plenty of issues, actually. It means one thing is all those issues connected with the collaborators. It means what to do with them. Then the second issue, which is a separate issue, is access to the files, right? They are usually together, put to the same bag. It means called lustration. Translation of lustration to English is usually as vetting, right? But I disagree. It's not a vetting, because the vetting is a normal procedure in the West, when from the point of view of national security, it's possible to block appointment of some people to some position. Here was not a vetting as such, it seems to me, especially if we look at the models. What's happened in the Polish case, that was not a lustration law, sensu stricto, but adoption of the soft model of a lustration lie law. If you know, that requirement was, okay, to fill some position, people who occupy some position, they are obliged to make a statement. I was or I was not conscious collaborator with the secret services. If this person wrote, I was, that's the end of the story. Nothing happened. But if the person wrote, I am not, I was not, and then in the archives, there are documents that such person was. So the punishment is only in relation to not collaboration, but to lying. So it seems to me that motives behind the Polish lustration law was not a punishment for collaborators, but rather to keep up some virtue, let's say, standards. I don't know, cnót publicznych, prawda? Some virtue standards in public life. Now, if you compare, let's say, to the, Izzy will say better than myself, to the Czech much more tough model, or let's say Lithuanian model, which it seems to me is even tougher than the Czech model, then was a really a lustration law as per se. So it means it's again, we talk about lustration, but let me repeat, plenty of different phenomena are put together under the name lustration, and then even the models of lustrations are different in the different countries. Did I satisfy you with my answer or not yet?
The Constitutional Tribunal and the human rights organizations, criticism of the lustration and how they evaluate.
Or the softening up, or let's say input to the lustration. Look, the effect, if I want to make an assessment of the effect, was actually minimal, actually, nearly close to none. Is my assessment, right? And be honest with you, that one of what's happened in this country, sorry that I haven't been involved in this, been somewhere else, but was too late. Right, it's really something which happened, after what 1997, the beginning of the process and so on. So it means late. If it happened quickly, right, then probably there should be much more. Właśnie, trudno, tak jest, ale szybko.
Yes, you're right. It should be fast after.
4th of June, let's say, 89. But then the results will be probably much more visible. Why? Let me stress again. One of the biggest problems of transformation in the Central Eastern Europe, and that's why TJ, I've got some doubts, is what? Massive privatization. It means we can't separate the issue of or focus only on the moral suffering or suffering of victims, because somehow here the most important elements, and I really admire work by Dr. Tyszka, our organizer. He wrote a fantastic, PhD about it. That's the point. It means some people use their political position and knowledge and became simply beneficiaries of transformation. Therefore, if we early introduce lustration and restitution of property, small one as happened in the Czech, block this group from getting to get economical power. And as you know, in this world, if you've got economical power, that's easy to translate to political power. And that's it. Thank you.
I know it's extremely rude of the moderator to exploit his position, but because Segur probably addressed also the question to me very briefly, as much as I was critical, and always was critical, of the Czechoslovak lustration law, it was certainly an early measure of, we never talked about transitional justice. It was always about transformation, what Adam has just said, social, economic, political transformation, and the measure was taken as a preventive measure to stop certain groups of people from accessing certain positions in administration, which was, so lustrations law was justifiable on two grounds. It's a temporary measure, that's why, transformation. And second, democratic legitimacy beats lustration. So offices held by democratic vote are not subject of lustration, and therefore are. So it was very limited for the purpose of protecting the state administration for a limited period of time during democratization of the regime. There was never a big discussion about, or moral dilemmas about blocking top communist officials or blocking members of the party militias was never an issue. The big issue was secret police agents, reliability of evidence, and obvious obviously the Czechoslovak model was based on, because it was all well administered, relatively well administered by the police before, so every agent had to put a signature in the register. So this formalist evidence was then taken as the crucial evidence. Highly controversial, nevertheless, it worked. Yeah, and it's so illustration ceased to be an issue for a certain time. Now it's coming back as a historical issue. Mm-hmm. Sorry. Next round of the questions. I think we still have.
It's very important problem. The problem illustration for Ukraine, but the problem is which way to implement the process of illustration in Ukraine, but approximately 18% of Ukrainian society had close relation with KGB, with secret police. It's a serious problem. Which way to implement model of illustration in this situation of very bad past?
And the problem is also that lustrations often have not been perceived as a preventive measure, but as a retributive measure, as a form of punishment. This is also a problem. But the Polish model is much closer to ethical judgments and virtue. As Adam said, it's a matter of virtue rather than a matter of administration. We have more questions.
To add one last, I mean, there's also the function of lustration measures to actually gain truth. This is what you see in Estonia in particular, that they ask people to, they give incentives for people to step forward, report themselves, not in this form of signature, but literally to tell them how the KGB worked, because that is then seen as valuable information to understand how the FSB is working today in Russia, so to have that kind of insights that they would otherwise not get. That's also a purpose of lustration in some way, if you want.
In Russia, you can lustrate head of state. The next question.
It's working. The risk, of course, of dealing a lot with the past is that we leave the future out, and actually transitional justice or a coming to terms with the past is meant for... Okay. Coming to terms with the past is meant to eventually leave the past behind, prevent the risk of repeating violence, and then moving to a better society in the future. And I thought it's interesting that in this panel, Istvan's comments about how actually visions for the revolution and how to avoid the terror that comes after the revolution have actually preceded the transition in Poland, as he mentioned. But also, I think we've seen how these measures to address the past, compensation and illustration, meet these different visions for the future, national visions in all these struggles in each country, national visions, European visions, global visions. I mean, different visions for the future are actually mixed, and kind of this maybe is a debate that, of course, is very hard to solve. But it's a side of some sort of a dynamic between past and future, I think, not just the past and kind of settling that, and that's it.
Thank you. This is a question for Adam, but Eva, I'd also like to hear your view on it. So Adam, given your gripes regarding the term transitional justice in general, do you think it's important to start delineating or narrowing down the concept in order for it to once again become a useful analytical tool for explaining the transformations in Poland, Eastern Europe, or the post-communist world in general? Thank you.
That was exactly my point before, that I think that there is a danger of overstretching this term to cover all sorts of dealings with the past. And then we should call it dealing with the past, and rather than transitional justice. And I mean, I think one can talk about how far it goes. You know, it's not necessarily that transitional justice is over in the Eastern European context in '93 with the first turnover of power or something like that. But it can stretch longer. That's fine. But I think that later struggles for recognition, for changing the narrative of the past, for changing textbooks, for these issues, they, from my point of view, have nothing to do with transitional justice anymore. And by packing that all under one term, we are losing the analytical clarity that we would need to really understand the mechanisms that are going, the dynamics that are going on.
Yeah, just a few words. I agree totally what Eva said just before, that that's not concept. It's just that keyword. We put everything in the concept of transitional justice. There is a dealing with the past, post-colonial situation. There's a problem of Aborigines in Australia. Let's say stolen generation, which means all abuse of human rights and all type of conflicts are put together to the transitional justice. But the last sentence is that to receive an analytical, let's say, to create a category with analytical potential, heuristic potential, what is it seems to be necessary to start from the social theory of social change. That's it seems to be starting point, not some institution, something else. But as long as some scholars don't have such theory, then they will put basically everything in this bag called TJ.
Any more comments, questions? Yeah, I can see one. Other? I think, yeah, it's late into the day, and okay, so we have two more questions, and then I will invite the panelists to, yeah, here and here. Yeah.
To retire.
And then to
retire. Proszę Państwa, ja chciałem...
Ladies and gentlemen, I would like to come up with a very particular piece of information after 3 days of debate on the transformation of political system and transition. I don't know if you realize, ladies and gentlemen, that at the turn of 1960s and 1970s, the American Nobel Prize winner on economy, Galbraith, suggested how to blow up the socialist camp from inside out. And he suggested to offer credit and lending to those countries, and the World Bank decided to extend lending to individual countries, to the Soviet Union, to Poland. So they offered massive lending to those countries. This was the first step that was taken, suggested by Galbraith. The other idea was to turn the armaments race to the extreme, because back then this was like the exploding of military installations in the space, and if the arms race would gain momentum, then the socialist countries headed by the Soviet Union within the Warsaw Pact and within the Comecon structure would go bankrupt in 6 years' time. This was realized by Gorbachev when he wrote the book Perestroika and the New Way of Thinking. But this was the follow-up to the initial suggestion from Galbraith.
I want to Stanislav Labiak, Bratislava, National Institute, Slovakia. I think that in the future we have to organize a special conference on other aspects, on all human aspects, because crime of Nazism, communism, and transitional justice, it is from other point of view. It depends on psychology, psychiatry, philosophy, theology, and other human parties. And I think that we have to think about a special conference in the future on this term. Thanks.
Thank you very much. If nobody else wants to ask a question, make a comment, we have final 5 minutes, so I'm inviting our panelists to say whatever they feel needs to be said. Okay.
Thanks for interesting comments and discussions. It's very interesting for me, the problem historical justice and its present legislation in Ukrainian constitutional process. It's the real problem for Ukrainian transformation. Which way to find cultural ground for this transformation? Unfortunately, in the condition of the absence of civil society cooperation, in the context of absence of social cultural foundation for changes, it's not easy to find common ground for historical justice, for implementation new rules and norms in Ukrainian constitutional process. It's probably it's necessary to find new forces for implementation of new norms and rules. Probably the intellectuals community in post-Soviet, Central European and Eastern European countries, intellectuals as community can be main factor for transformation in economic and constitutional and cultural social evolution. It's probably its main factor is to find the community as a spiritual force for evolution.
Okay. Thank you very much. It's been a long time since I heard such high hopes about intellectuals, and it almost feels like nostalgia. Adam.
No.
Eva.
Oh,
Eva, the ladies.
Well, I don't really have much more to say than that this conference really gave me a lot of fodder and things to think about. What I'm always fascinated about is that how domestic truth and justice processes then have sort of reverberations on the European level and really affect not, have maybe effects on neighboring states, but more on the European debates. And this is something that I think we will see much more in the future, and that is an exciting field to study, precisely this connection between domestic processes and then the European debate. But that's more sort of my own thoughts that I take from here, and otherwise I think this was a very fruitful dialogue between different disciplines and different approaches, and I very much enjoyed myself.
Thank you very much. And Adam.
Well, I could only say that first of all, thank you very much for organizers for organizing this conference. That was sort of the wrapping up, it seems to me, and of the summary of the experiences with practice and reflection upon the transitional justice in this part of the world in last 24 years. What I see, it seems to me that the necessary is to make this distinction between the practice and the reflection, and sometimes they were fused together, right, in our own approach. Then the second point, what I want to stress, is still I see this lack of the proper amount of research done on the interest plus property issue connected with the transitional justice. That has to be somehow changed. And the third element, it seems to me, that's something reverse. It means what I started to talk about. It means a colonization of memory. It means to what degree all those institutes, for instance, of national remembrance, they are playing not only positive, but some ricochet, the role, which is the negative role of the colonization of the national memory. That's a short summary, the most important issue I identify today. Thank you.
Thank you very much. And I also, in the 30 seconds which I have, want to thank all the organizers for putting all this together. I want to thank all the panelists, all the participants for asking questions, and in particular I want to thank the translators over there who provided us with most excellent and the technical staff over here, and simply to everybody for coming and being here. Thank you very much. It's been great. And now the final address by Jan Riedel, and yeah, please.
Dziękuję bardzo.
Thank you very much. I'm going to speak Polish, ladies and gentlemen. During our conference, we listened to 30 papers. There were many discussions on philosophy of the law, history, culture, sociology, and especially we listened to presentations and opinions on areas where these sciences overlap. All these presentations were centered around transitional justice. As Professor Czarnota says, well, TJ, he uses this petty name. So coming to terms with guilt, crimes of the past political system. It is a problem of societies of the transitional period. It was the transition from totalitarian and authoritarian systems to democratic systems. It is clear. The significance of the problem, which I could feel tangibly listening to all the papers and all the contributions, the significance of the problem is connected not only with the fact that it pertains to the transitional justice pertains to difficult, dramatic, traumatic phenomena of the past, and these phenomena of the past were very harmful, painful, and they go against the grain of a sense of justice. But, in my opinion, it was very important because in the transition period, coming to terms with the past was at the same time one of the most important elements of building foundation of the new order, of the new quality of societies. So the TJ problem is not only oriented onto the past, it is actually the element co-defining the future of Central Europeans. Additionally, I would like to emphasize the great significance of all these topics, which is exceeding just scientific aspects of these phenomena. I would like to reverse the situation, and perhaps I should say the following. I can ask a rhetorical question: what are views for the future if there is a society that observes that perpetrators of crimes, torturers, oppressors, perpetrators of forced removal of displacements will not be punished, that victims will not be redressed in any way? What will be the future of such a society that would have such observations? I would like to show you a satirical image by a very well-known Polish satirist, Andrzej Mleczko. I remember I was under great impression Actually, it was like drawn 30 years ago. And at the top part of the cartoon, it is written, "The new is coming." And it was the year of solidarity movement. The new is coming. But at the bottom, the old is driving. So the new is just walking on foot, and the old is simply driving, because the old regime has huge tools, is richer, more experienced, so the old regime held quite well, despite of the new coming. So what about prospects for the future of the societies who forget about administering justice? The societies that are ineffective in administering justice for wrongdoings of the past. Such negligence destroys morality of the science, destroys morality of the society, destroys moral values of the societies. When our societies are trying to follow the new order, are trying to open a new chapter in their history. I am deeply convinced that the conference, which is about to be closed, will become an inspiration, or perhaps even a milestone in our approach to transitional justice in our region. And it will happen thanks to bringing together in one very nice place, very nice venue, in bringing together so many eminent researchers, academics, specialists on the topic. Thanks to interdisciplinary approach, which was achieved thanks to your contributions, which, for me, I am just a historian, and for me this interdisciplinary approach was absolutely impressive. And I had many moments of revelation here, so a great value of the conference is the multitude of perspectives, reflections, which were general and more specific, so many perspectives in one place. First of all, now I would like to congratulate on all the papers. I would like to congratulate panelists, speakers, the audience, and I would like to wish to all of you that the conference may start exerting its impact on a wider group of recipients than just our audience. So I would like to announce, well, it is quite obvious, but we will try to publish the conference materials as soon as possible. And if there will be good editing, we'll have something more, something even more valuable than just post-conference materials. It may be a very important source of knowledge on transitional justice. It may be very beneficial for us in the future, because I believe that in Central and Eastern Europe, we've had many attempts, we've achieved a lot, but a lot needs to be done in terms of transitional justice. Now, I would like to express my thanks. I'm glad Professor Przybań started thanking many people, so I would like to thank participants of the conference, first of all. I would like to thank organizers, the European Network Remembrance and Solidarity, Collegium Civitas, the Institute of Social Prevention and Rehabilitation of the University of Warsaw, and very special thanks to Małgorzata Pakier and Stanisław Tyszka, because these are the people who set the right direction, and they contributed a lot to preparation of the conference. I would like to thank the team of the European Network, Remembrance and Solidarity, Agnieszka Nosowska, Hanna Gospodarczyk, Edyta Mietkowska, and Elżbieta Moczarska for the huge effort, great contribution to preparing the conference, for all the work they have done. I would like to thank our partners, institutional partners who supported us, sponsored. We were sponsored by the National Center of Culture and the Visegrad Fund. And finally, once again, I would like to say thank you to our interpreters, because without them you wouldn't be able to understand me, for example. And now, additionally, I would like to show and pass on to the Presidium a certain souvenir from the conference. It is not directly connected with the TJ concept. It is rather an example of our activities as the European Network Remembrance and Solidarity, a very serious, I don't know how to call it, a very serious souvenir, let me put it like this, commemorating a tragic history of this part of Europe, the 23rd of August, 1939, which was the year and the moment of concluding Ribbentrop-Molotov Pact and Stalin-Hitler Pact, which became later on the source of many atrocities and dramas of our part of Europe. Thank you very much indeed.